Hi, everyone, and thanks for joining today. This is Brian Pratkin. I'm a partner in the McGuireWoods Richmond office, and I co-chair, along with Bethany Lukic, McGuireWoods Class Action Practice Group. We're excited to have everyone here today, and you'll be hearing from me and three of my partners, Bethany, Trent Taylor, and Matt Kane. I'll let each of them give you a little background on his or her practice before they speak. The areas we'll be covering today hopefully cover the gamut of what's important in the world of class actions, both for what happened in 2020 and what's on the horizon in 2021. So we have a lot to cover in the next hour. I'm going to go first to discuss the Supreme Court developments. You may have seen an earlier invite to this webinar where we had Katie Barber slated to present on this topic. She's a former Justice Ginsburg clerk, so I think you would have enjoyed some of her insights, but she's unfortunately out sick today, so I'm going to be pinch hitting for her. After I go, you'll hear from Bethany on a few topics, including COVID, Europe, consumer and data privacy class actions, and then Trent on products liability and food labeling class actions. And then last and definitely least, Matt Kane on labor and employment and wage, hour and wage law. We put him last because he always goes way over his time allotment, so this is some payback for him. So on to the Supreme Court developments. Just real quickly, my practice is primarily in the financial services, consumer financial services arena. I do class actions along with other litigation in that area that involves single plaintiffs as well. And so the first two cases I wanted to talk about involve the TCPA. There's an opinion that came out last year that those of us in the defense bar had some high hopes might gut the TCPA, and then there's an opinion that was argued just a couple months ago, and we're sort of on the edge of our seats waiting for the Supreme Court to decide that. So the Bar versus American Association of Political Consultants case, which was decided last year, involved an exception to the TCPA, which, just as a little bit of background, most of you probably know this, but the TCPA bans robocalls to just shorten it. And this particular exception allowed the government to make robocalls, or debt collectors on behalf of the government to make robocalls when the debt that was at issue was owed to the government. There's a group of political consultants who wanted to make robocalls and thought that it was unconstitutional for the law to give an exception to government debts, but not for their own calls. And so they argued that the law was unconstitutional and restricted the First Amendment rights. In a plurality opinion, the Supreme Court found that this part of the law was unconstitutional, but the plaintiffs in that case didn't get really, or the political consultants in that case didn't get what they hoped for. They had hoped for a complete striking of the really the meat of the TCPA, finding that the robocall prohibition was entirely unconstitutional, which would have just gutted the statute as a whole. Instead, they got a holding from the Supreme Court that said the ban that favored the government was unconstitutional, but was easily severable, and therefore really didn't get any relief that was helpful to them. That maybe one sort of takeaway that might be interesting from that opinion was that Justice Kavanaugh, who wrote the plurality opinion, said in passing that Americans disagree on a lot of things, but are largely united in their disdain for robocalls. And so we had that opinion coming into the end of 2020 with the next opinion, which is the Facebook versus Dogood case. That case, and I will spare everyone the grammar that was at issue in that case, it would make my high school, and I'm sure everyone else's high school grammar teachers, very proud in the discussion. But it had to do with the definition of an auto dialer and whether the term store or produce, Facebook was arguing that the use of a random generator must apply to both the verbs store or produce. And like I said, I don't want to bore you with all the grammar issues, but at the end of the day, what Facebook was arguing was that the technology that it had did not meet the definition of an auto dialer, and therefore their text messages that they were sending were not banned or barred by the TCPA. Under the plaintiff's view, which would have been a broader definition of the auto dialer definition, all of Facebook's text messages would have been or would be banned by the TCPA. And the oral argument for the TCPA nerds out there really got way into the weeds of grammar and context of how the statute should be read. I think given the makeup of the court, most folks are walking away thinking that the Supreme Court is going to rule in favor of Facebook and a narrower definition of what an auto dialer is. And if it does that, then there's a lot of speculation that Congress or the FTC will just fix that in an amendment to the statute. The TCPA, as you all may know, has pretty severe penalties for both individual plaintiff cases and class actions, as every call that is improper under the TCPA can result in a $500 to $1,500 penalties. So those are the two cases on the TCPA. I think we're expecting a ruling in the Facebook case sometime this spring, so stay tuned. I'll move on to two cases on Article 3 standing. The first one I can deal with pretty quickly. I don't know if it's Thole or Toll versus U.S. Bank. That, although it was a class action, the class implications are not super important because the named plaintiff or plaintiffs themselves did not have standing. They did not have an injury in order to state a claim. And so the Supreme Court, it was a close call, it was a 5-4 opinion, but the Supreme Court found that the plaintiffs in that case did not have standing to assert claims under their benefits plan in that case. I want to spend a little bit of time on the TransUnion versus Ramirez case. This has got my attention and those of us who practice in the consumer financial services world has our attention. It involved the Fair Credit Reporting Act. The petition was granted in December and has not been scheduled for oral argument yet, but we expect it'll be scheduled in the spring. In this case, the plaintiff went to a car dealership purportedly to buy a car and had a credit report or a consumer report pulled on him through TransUnion. And that report had an alert on it that he was a match on the OFAC list. And it's essentially without apologies to him, but it's essentially a list that identifies terrorists or potential terrorists in the United States. Well, it turns out he was not a terrorist. The name that was on the list was his name, but a different person. And the result was that he could not apply for a car in his name, and he had to cancel a planned vacation. So he sued on behalf of himself and anyone else who had a TransUnion credit report that had their name as a match or potential match on this on this terrorist watch list. And the case went all the way through jury trial. The jury, as you can imagine, was offended by TransUnion listing him as a terrorist when he wasn't one, and awarded him and the class almost the maximum of statutory damages, which was close to $1,000 each, and punitive damages of $6,000 each. So the total verdict was about $60 million against TransUnion. That went up on appeal to the Ninth Circuit. The Ninth Circuit reduced the punitive damages award down to, I think, $30 million or so, but left intact the statutory damages award. It got stayed down there so that TransUnion could appeal to the Supreme Court, and the Supreme Court granted cert. And the issue for the Supreme Court is whether the other class members, not the named plaintiff, can sue regardless of whether they have any actual injury. And so while it's pretty easy to see how the named plaintiff had an actual injury because his name was provided to this car dealership, and so he couldn't get the car and apparently had to cancel this vacation. But the rest of the class members, they're in the class only because their names were on this list, but there was no evidence that they had their names shared with third parties. And so the issue for the Supreme Court will be whether class members who have not proven or even alleged any actual injury have standing to bring their claims. And you can see the potential consequences here. Normally, the way we litigate class actions is the standing of the individual plaintiff. There's a body of case law that you all are probably familiar with under Spokio, where the named plaintiff has to have an actual injury, a concrete and particularized injury, and then a lot of times there will be litigation over whether the named plaintiff can bring the claim or not. In this case, we sort of moved past the named plaintiff, and now the question is, assume the named plaintiff has an actual injury. We're not worried about that. We're looking at whether the class does. So that ought to be a really interesting argument, and I think if it comes down in favor of TransUnion, will really affect class action practice in the financial services world and other cases where the class itself may not have an actual injury. I'm going to yield the rest of my time to Bethany and let her go next. So if we have time at the end, I might come back to the securities claims, but I'll let Bethany take over next.
All right. Thanks, Brian. I'm Bethany Lukic. I'm a partner in our Los Angeles office, and as Brian said, I'm one of the co-leads of our class action practice here at the firm. I sort of have a catch-all group of discussions today, which sort of mimics my own practice in the class action space. I predominantly focus on consumer class actions, but within that sort of very broad area, do some labeling class actions, both in the food and beverage space, but also in other retail products. Do some antitrust class actions as well, and then also more recently, as California's privacy laws have developed, have been focusing also on privacy class actions. And so I'm going to give just sort of a broad update in all of these different areas. And I'm going to start with a little bit of a discussion about what we've seen in terms of COVID-related class actions. I'm not going to spend much time here because I think that most of us, like me, are very over coronavirus and would like it to disappear as quickly as possible. But as 2020 was really consumed by COVID-19, there was a lot of activity in the class action space related to coronavirus. We saw sort of the initial class actions come out related to the cruise industry, but then they quickly, expanded into other areas, financial services, education, employment, event and flight cancellations, consumer protection claims, and these are primarily labeling claims, and then also some securities litigation. So I just want to touch on a couple of these areas. So in the sort of consumer space, there were a bunch of class actions dealing with cancellations and closures and deceptive advertising and price gouging claims. So for example, people who were upset if they didn't get full refunds for events that they had paid for, people who didn't get monetary refunds for flights that had been booked, or dues that were paid at various different places. I will say that a majority of the cases sort of in the COVID area, we saw a lot of dismissals, we saw a lot of repleading, we saw some settlements, but not a whole lot of actual substantive decisions have arisen out of this sort of general area. We did see one denial of certification associated with the cruise line industry over claims that, that the cruise line should have warned consumers that and should have known of the risks of coronavirus, but due to class waivers in those tickets, the court denied certification, and that was out here in California. As indicated, we also saw class actions in the financial services space. I think the sort of largest group of these class actions related to the CARES Act and PPP loans. There were sort of two types of cases in this area. One related to how the loans were initially distributed and who got loans and who did not. And then there were a series of cases relating to agent fees. The agent fee cases have almost exclusively been dismissed. That was the result of some motion practice sort of across the country in the various different jurisdictions, along with a clarification of the CARES Act that came out before the close of the year. On the sort of distribution side, those cases are also dwindling greatly and or being moved to arbitration. On the education side, there were a lot of cases. I think there were more than 60 cases that were filed against institutions of higher learning associated with tuition. Some of these cases have been dismissed, but again, no real substantive decisions in the space. It's something that we're looking at because I think while hopefully coronavirus and this pandemic goes away, certainly the decisions that come out of these cases could have longer lasting implications. And I'll just end on a sort of a plug for a book that's coming out in conjunction with the ABA that has been edited by some of my colleagues and partners at the firm, Davis Walsh and Sam Terry. It includes a chapter on class actions related to infectious disease litigation. There's also a chapter in there about multi-district litigation and mass actions. And that book comes out February 12th, 2021. So if you're interested in sort of a more in-depth analysis of these types of class actions and some of our analysis. You might want to check that book out. From there, I'm going to move on to Europe. I put this in here even though, this is really an update about what's happening in the class action space in the U.S. For those of you who might have a more global practice, the European Union, of course, has typically not had any sort of class or collective actions. However, in April of 2018, there was some legislation introduced, and the Parliament finally endorsed the legislation in November of 2020. And basically what it allows is that collective actions can be brought by certain designated consumer organizations on behalf of other consumers. Who these designated consumer organizations are is primarily left up to each individual member state. However, for cross-border types of lawsuits, those entities are defined, and essentially they're nonprofit entities who are advocating on behalf of consumers. Another interesting portion of this legislation is that in various different countries can also decide whether their citizens will proceed in or participate in these actions by way of opt-in or opt-out. In the United States, of course, we have an opt-out philosophy that you are part of a class unless you specifically opt out, and therefore any judgment covers you if there is a judgment or certification or settlement and the like. In Europe, they are leaning, as they do in many different instances, with an opt-in philosophy. So, in other words, consumers would not participate in any sort of collective action unless they specifically opted in. And while it passed in November, there's sort of a huge lead-up time to these sorts of actions. There's going to be 2 years basically for each member state to sort of put this into law and figure out how they want to implement it, and then another 6 months to actually implement whatever practices they put in place. And then finally, I think the European Union and Europeans are very concerned that the collective actions and these class actions would take off like they have in the United States. And from speaking to overseas clients, often they sort of criticize the system as being so overbearing and so expensive for businesses in the United States. And so in order to sort of safeguard against that, they have put in a loser pays principle into the act, so that presumably if a consumer or a consumer group brings a frivolous suit or brings a suit and they are not successful, they would have to pay, although there is protection in this loser pays principle for individual consumers. So these collective claims can be brought in various different types of litigation: consumer, data protection, financial services, travel and tourism, energy, telecommunications, environmental, health, and air and train transportation. So that'll be interesting to see how that develops, and wanted to bring that to your attention. Next, I wanted to sort of talk a little bit about a debate that's happening in the various different circuits with class representative incentive awards. As you all know, when if there is a class settlement, oftentimes the class representatives get a fee or an incentive award that exceeds what that class representative would normally get if just participating as a participant in a settlement. And the case I have up here, Johnson versus NPAS Solutions, was a TCPA case. And there's a lot of discussion in the case about the fact that it was quick to settlement. It settled in less than 8 months. There was very little motion practice and discovery. And the total settlement under the case was about $1.4 million. And the class rep was awarded $6,000 for his role in prosecuting the case. There was only one objector to the action, and that objector raised that these incentive payments were contrary to Supreme Court precedent and created a conflict of interest between the class rep and the other class members. And in the analysis, which involved two Supreme Court cases, Trustees versus Greenow and Central Railroad and Banking versus Pettis, the court stated that basically, you couldn't look, these two cases are often overlooked in actual practice. And these cases stood for the proposition, again, before Rule 23 was really amended, that you couldn't give money for, quote, personal services and private expenses. And the court likened incentive awards to a salary, basically, for personal services and private expenses, and said that they were not at liberty, basically, even though this incentive award practice is incredibly widespread, to basically sanction that practice. And therefore, they overturned the lower court ruling holding that these incentive payments were acceptable. That case is up. There was a petition for rehearing en banc of that case that was filed back in October, and we're still waiting to see how that shakes out. In the interim, the Sixth Circuit has spoken up in Shane Group versus Blue Cross Blue Shield of Michigan, and specifically focused on some language in the 11th Circuit, which likened these incentive awards to bounties promoting litigation. And in this case, the court said that the incentive awards were appropriate and that in no way did they see named plaintiffs' service awards to amount to a bounty, and that argument or that discussion was, quote, meritless. So there is definitely a debate in the circuits, and it'll be interesting to see as these cases and as settlements go through in the upcoming months, year, to see how the various different circuits and courts below treat these incentive awards, which are very, very common in the class action settlement space. And then finally, I want to touch on two different trends that are happening in the data privacy world. The first trend is sort of out here in our neck of the woods, dealing with the CCPA, which is the California Privacy Act that went into effect. I guess it's not been that recent right now, but the first class actions under the CCPA started to get filed last February, and we've seen over 30 cases be filed that implicate the CCPA in some way, shape, or form since. For those of you not familiar with it, the CCPA does allow for statutory damages in the event of a data breach. Those statutory damages range from $100 to $750 per violation. And The debate really is, are those the only types of damages, breach damages, that may be pursued in a private right of action, in a class action, or are there other types of violations that can be pursued that fall short of a breach? And, we would argue on the defense side that the drafters of the CCPA and the comments associated with the CCPA foreclose class actions or private right of actions outside of the data breach area, but that concept is being tested. There are some CCPA claims for non-data breach violations. And then there are the more creative approaches where plaintiffs are bringing actions under the consumer protection laws of California, the UCL and the CLRA, for other violations of the CCPA. So far, there really haven't been any decisions of particular note. There was one CCPA claim that was dismissed, but that was unopposed. And we have one breach situation where a motion to dismiss was denied. But otherwise, those cases are all in the early pleading stages, and we don't have any decisions. So this is really it's a new statute. It's a new interpretation of the statute, and we're watching closely to see what the courts do. And then finally, the final trend, because I'm running out of time, is under the BIPA class actions. BIPAs are Biometric Information Privacy Acts. Currently, Illinois is the only statute out there that has a private right of action, and that's where all of the action is. The most notable case right now is the Facebook case, where there was a $650 million settlement that was preliminarily approved, and then the final approval hearings happened last month, but we still don't have a decision. It's noteworthy because of the size of the settlement. Judge Donato had initially rejected a $500 million settlement, but this $650 million settlement would generate, if every single class member filed a claim, damages at $338 per person or per class member, which is really significant in this sort of privacy space. I think with other class actions that we've seen and class settlements that we've seen for data breaches, the damages are much, much, much smaller than that. So this is really groundbreaking in that area, and we're watching to see what impact that has. But we've seen a whole lot as a result of the size of the settlement. We're seeing increasing activity here. We're also seeing increased legislation. So with that, I'm going to turn it over to Trent.
All right. Well, thank you so much, Bethany. I primarily defend product and food beverage labeling class actions, and there are a lot of those. And so what I wanted to do today is explain some of the recent trends that we're seeing, and then what we sort of predict happening in the future. So let me just start with, where are these class actions being filed? So historically, most of these class actions were filed in the Northern District of California. But in recent years, they've been expanding out to a lot of other jurisdictions. And really, you'll see these just about anywhere these days. But we're seeing a couple of places, or a few places, where there tend to be more. And these days, that's Florida, Illinois, in New York. And in particular, I wanted to mention New York because they had more product and food and beverage labeling class actions filed in New York federal courts this year than in any other jurisdiction, overtaking California. And that was mainly because of one plaintiff's lawyer who decided to go to war with the manufacturers who use vanilla flavoring in a lot of food products. And he filed dozens and dozens and dozens of those lawsuits, and many of them are still pending. And that leads me to my second trend, which is industry-wide attacks. So there used to be scores of these one-off labeling class action suits targeting, label claims like natural, that kind of thing. But what we've seen in recent years is that many manufacturers of these products, they stopped making what you might call outlier claims, and they started herding, where everyone is essentially making the same claims on their products. And part of this is, they think it reduces the risk if they are having the exact same label claims that everyone else in the industry does. But the newest trend has been to go after those claims. And what the plaintiff's bar does is they find a label claim that they think is deceptive that everyone uses, and then they will file suit against numerous defendants simultaneously. And we've seen it in several, places thus far, our recent targets, and those include the vanilla flavoring, which I mentioned, infants' medicine, and then ground coffee. And just to give you a sense of what has been a target for ground coffee, it's what you might see on a lot of those labels that says makes up to X number of cups. And their claim is that, no, it actually doesn't make that number of cups. So that's something to keep an eye on. Something else that I wanted to mention is the re-emergence of the reasonable consumer standard. Now, this is a justification used by some courts to grant a motion to dismiss in these labeling class actions. And it essentially is where the court will hold that no reasonable consumer would be deceived by the label claim at issue. And the fact that, courts are willing to use this to dismiss cases at the motion to dismiss stage of a case is obviously a very good development for defendants. And let me give you an example. So you can see this first case mentioned on this slide, the Happy Cow suit. And essentially the label claim there that was at issue was that Ben & Jerry's had happy cows. And that was actually a claim that was on their website. And so they got sued saying that, this is deceptive advertising, and the court dismissed. And you can see what it said there. It said that it's unreasonable for a consumer to interpret a single phrase in a single heading without reference to the contents of the section that immediately follow the heading. And the court dismissed it. And we've seen that in a number of other suits as well, especially the vanilla decisions, where 5 of those have been dismissed in New York federal courts in the last few months, essentially on this basis. So that's a trend to watch out for. It's a very good trend for defendants, and we'll see if it continues. Another trend is the front versus the back label. And what I have here on this slide is a very recent Seventh Circuit decision from December of 2020, Bell v. Public Supermarkets. And let me tell you a little bit about this case. So this had to do with, it's actually an MDL related to 100% grated Parmesan cheese. So this case was actually dismissed by the trial court in part because the district court found that the 100% grated Parmesan cheese was ambiguous. Maybe it was just 100% graded rather than 100% Parmesan. But the plaintiff's theory is that, that meant that it was 100% Parmesan when it's actually not. And if you look at the back label, it actually has between 4 and 9% added cellulose powder and potassium sorbate, which are used to fight caking and mold. And so that became the issue. And what the Seventh Circuit held in December is they reversed the dismissal and basically held that just because you have an accurate ingredient statement on the back, that doesn't foreclose a claim if there's another ambiguous label statement that deceives a reasonable consumer on the front label. And so essentially, going back to that for just a second, what defendants need to do is look at the totality of their label and make sure that they're being consistent throughout both front and back label in order to reduce the risk of one of these class actions. Now, I want to compare that to a Ninth Circuit decision that came out late last year as well. In that, the Ninth Circuit affirmed a dismissal of a complaint, finding, and that had to do with Pop Secret, and it had to do with the fact that it contained artificial trans fat. But the reason why, in this case, the dismissal was affirmed is that there was not an affirmative statement on the front label, that was cured by the ingredient statement. And the court essentially held that. It said that if you don't have that affirmative misleading statement, then there's not a deception that has to be cured. So that's something to watch out for as well, and we see that in a lot of different cases. Simply having a plaintiff's assumption that a product is X or Y is not enough. There needs to be an affirmative misstatement on the front label. And the last trend that I wanted to sort of focus on from 2020, and I think it will continue, are some of a few of the popular targets. So first of all, any kind of flavoring is a popular target right now. The same plaintiffs' counsel who has gone after vanilla flavoring is now going after other flavorings, such as lemon, smoke, botanicals, that kind of thing. Anything that, and his, theory is that these flavorings are actually synthetic, and therefore it's not correct to call them, vanilla or smoke or lemon because it's synthetic. Country of origin is another big one. I'll give you an example. If a company is giving off a vibe that they are a Mexican beer, but they're actually manufactured in Toledo, then they may be targeted with one of these country of origin or region of origin labeling suits, basically saying that you made the consumer think it was from Mexico or a Mexican beer when it's actually manufactured in Ohio. And then sugar is still a big one as well. So a couple of trends for 2020 that I wanted to touch on very briefly. First, I anticipate, and I think a lot of others do as well, that there's going to be some structural changes in labeling litigation and really just class actions in general. I know Brian mentioned the TransUnion case. It's going to be interesting to see what happens there. Bethany mentioned the Johnson v. Impasse case, which we're watching closely. But I think we're envisioning courts further restricting the use of class actions and class action settlements and preparing for potentially a post-class action world. And the likely result could be more mass actions or lots and lots of individual actions as opposed to class actions. We also are expecting more regulatory actions from like the FDA, USDA, and with the new Biden administration. So we fully expect there's going to be a lot of changes in this space over the next few years. And then a few more targets that we may see going forward that I wanted to just flag briefly. One is eco-friendly claims, such as farm-raised, locavore, cruelty-free, that kind of thing. And we're seeing a lot of lawsuits starting to focus on these, and we're seeing a lot of companies who want to make these eco-friendly claims. Those are claims that resonate with a lot of consumers, but when they start being used, then they become targets. And so if a company is using these claims, you're going to want to make sure to substantiate the claims and that they are backed up with actual data. Another one, and in some ways this may be one of the biggest ones coming down the pipeline, is packaging. So if a company is putting on their packaging that it's sustainable or recyclable or compostable, they can become a target. And I'll give you an example of that, this is a suit that it was from last year from the Northern District of California, Smith v. Keurig, and it had to do with K-Cup pods, and the label claim it issued there was it's recyclable. Now, they actually are in fact recyclable, but they are not recyclable in approximately 60% of communities nationwide, and it has to do with maybe some of the contents of that K-cup pod, and they can be processed as recyclable in certain places, but not in others. Well, the plaintiff's bar filed a lawsuit saying, well, your claim of recyclable is deceptive. And lo and behold, this case got past the motion to dismiss stage. The court denied it, and class cert was granted. So that just, I think, exemplifies the threat of using some of these, types of claims on packaging, and we expect to see a lot more of those going forward. And then my final slide, which I'll mention just briefly, another trend that we see in this space, and we anticipate there's going to be a lot more of it, is class actions related to pesticides and chemicals. And, we've already seen a number of them filed, PFAS and others. We anticipate there's going to be a focus on different pesticides going forward. And what we see happening is the plaintiffs' counsel and nonprofits are buying lots and lots of products, and then they're testing them in labs for various substances. And they get a hit, even at a very, very low level, then they file suit or they send a demand letter. So it's some ways similar to Prop 65, but they're now going under the banner of deceptive labeling class actions. So that's what I have. With that, I will turn it over to Matt.
Matt, you may be on mute.
Sorry about that. Good morning, everyone, or good afternoon. My name is Matthew Kane. I'm a partner in the Los Angeles office of our firm, and I'm one of the leaders of our National Wage and Hour Class Action Defense Group. So the first case I want to talk about, and just came out last month, and is in the FLSA collective action certification space, is Swales v. KLM Transport out of the Fifth Circuit. For those of you that deal with FLSA collective actions, it's pretty common that throughout the country courts deal with the so-called conditional certification issue through a two-step process that was first articulated in the Lizardi versus Xerox case. And just to summarize, that process is at the beginning of the case, the court decides whether to grant conditional certification in order to issue court-supervised notice to so-called similarly situated members of a proposed collective. And the standard for granting conditional cert just to issue that notice is very, very lenient. It's been compared to the old saying about grand jury indictments, that a ham sandwich could be indicted, sort of a similar approach. And in fact, some courts in the country will not even hear evidence to decide the issue. They'll just decide to grant conditional cert based on the allegations of the complaint. And once conditional cert is granted, notice goes out to the proposed collective members, and then they have to opt in to become plaintiffs in the case. And then merits discovery ensues. And at the close of discovery, a decertification process is engaged in for the court to decide whether or not it should proceed to trial as a collective action. The Swales case out of the Fifth Circuit wholesale rejects that long-standing approach, finding no support for it in any precedent or the FLSA itself. It now, at least in the Fifth Circuit, takes the position that at the beginning of the case or early in the case, the court needs to identify merits issues to determine that it needs to determine whether or not people are truly similarly situated, and to authorize discovery on those issues and make a certification decision that is much closer in resemblance to a Rule 23 certification decision-making process. Now, this is just in the Fifth Circuit at this point. As I said, it just came out last month, and we can, I'm sure, expect to see en banc review practice as well as a Supreme Court cert petition ultimately, as well as efforts to get other circuits to adopt a similar approach. Next, I just want to touch on an issue also in FLSA collective action practice that's been evolving and developing over the last year or so, and it ties back to a Supreme Court case, Bristol-Myers Squibb versus Superior Court, where a personal jurisdiction issue arose as to whether a defendant could be subject to suit by out-of-state plaintiffs, and whether that violated due process and whether the court lacked personal jurisdiction. In the FLSA space, courts have been struggling with that issue. Some courts have taken the position, such as in the Camp v. Bimbo Bakery's decision out of the District of New Hampshire, that it did not have jurisdiction over or personal jurisdiction over out-of-state opt-in plaintiffs in an FLSA collective action, whereas the Southern District of West Virginia took a different approach or reached a different decision and found that it did have personal jurisdiction, mainly because both of the original name plaintiffs worked for the defendant in that state and were allegedly similarly situated. This is an issue that's weaving its way up to the circuit courts and will ultimately need to be decided by the U.S. Supreme Court, I'm sure. Next, I want to turn to the topic of arbitration agreements. And last year, in the FLSA collective action space as well, in Bigger versus Facebook, the Seventh Circuit decided that where proposed members of the collective are ostensibly covered by arbitration agreements, that court-supervised conditional certification notice can't go out to those people, but sort of laid out a process for having potentially early discovery on that issue in requiring an evidentiary showing of who isn't and is not covered by arbitration agreements, so that the court can know who to exclude from giving notice. This issue sort of falls into the category of be careful what you ask for. I won't get into it in large matter, but there's a phenomenon that's been going on in the last few years of so-called mass arbitration litigation, where there's a cadre of plaintiffs firms that have decided that they'll just go ahead if they can't get a class action or collective action going, they'll file hundreds or thousands of individual arbitrations and businesses like DoorDash and Postmates are two that have been in the media quite a bit in terms of their thus far unsuccessful efforts to stop that strategy from going forward. Also on the topic of arbitration, under the Federal Arbitration Act, which is what we all prefer to have our arbitration agreements enforced under when it comes to class and collective actions, because it's pretty clear that class and collective action waivers can be enforced under the FAA. There's an exception to FAA coverage for transportation industry workers who are engaged in interstate commerce. And I want to just touch on 4 cases here. The first two, Rittman versus Amazon and Wythaka versus Amazon, held that last mile delivery drivers who transport goods in interstate commerce are in fact exempt from FAA coverage, even though they never leave the state, mainly because they were delivering goods that were part of a stream of interstate commerce. Rogers v. Lyft and Cunningham v. Lyft involve, obviously, since it's Lyft, not the delivery of goods, but the transportation of people. And these are two conflicting decisions in California. The Rogers case, the court held that these drivers were not subject to the Section 1 exemption under the FAA because they were transporting people, versus in the Cunningham case in Massachusetts, it found that those drivers were subject to the FAA exemption because ostensibly the drivers play a significant role in transporting passengers from state to state. So that's one that issue is going to continue to be developed over the next year or so and wind its way up to the circuit courts and probably ultimately Supreme Court. Next, defeating class certification. We had a significant decision towards the end of last year in Castillo v. Bank of America, which focused on the issue of predominance for class certification. To summarize it quickly, the argument that we made on behalf of Bank of America was that we showed through expert evidence that there were proposed members of the class who, notwithstanding whether or not the policy or practice at issue was or may not have been fully compliant, that there were significant members of the proposed class that were never subject to it, and therefore there could be no liability as to them. Both in the district court and in the Circuit Court of Appeal, the Ninth Circuit, the decision to deny class certification was granted and affirmed respectively, finding that it was not a damages issue as the plaintiffs contended, but a liability issue, and because there were a lot of individualized issues as to who there may be liability for and who never even suffered any violation, class certification was not appropriate. Turning next to everyone's favorite topic, COVID. Just be on the lookout for class action activity in a number of areas related to the so-called reconfigured work environment during the pandemic. And these have been and will be focusing on things like business expenses that employees incur working from home, pre and post work activity in terms of screening and testing, whether or not people working remotely are getting all of their breaks and being fully compensated for all their time work, whether changes in the way that they're paid during the pandemic have resulted in a loss of their overtime exemption status, as well as, for things like hazard pay bonuses, whether overtime is calculated properly. For those of you who employ federally regulated truck drivers and hours of service regulated truck drivers, back in late 2018, the FMCSA exercised its rulemaking authority to determine that California's meal and rest break rules were preempted by the FMCSA's hours of service regulations that had their own break rules. Similarly, late last year, they exercised that authority again in holding the same as to Washington's break laws or break rules. When the California preemption decision was made, the Teamsters, amongst others, filed a petition for review in the Ninth Circuit. And much to everyone's surprise, particularly if you listen to the oral argument or watch the oral argument, the Ninth Circuit actually affirmed the FMCSA's decision, applying Chevron deference. And so we'll need to watch now for en banc review and further Supreme Court proceedings potentially. Then California, everyone's favorite jurisdiction for wage and hour litigation. I'll point out two cases that are of interest pending there. The Farrah versus Lowe's Hollywood Hotel case deals with whether the regular rate of compensation for meal and rest break penalty pay has the same meaning as regular rate of pay when paying overtime, meaning whether if there was a higher recalculated regular rate for overtime purposes, does that have to be used to pay 1 hour of penalty pay for meal and rest break violations. Similar or likewise, the Naranjo versus Spectrum security case deals with whether those meal and rest break penalty payments are subject to payment at termination, and whether they have to be reported on wage statements, which are constant issues in wage and hour class actions in California. And then finally, to wrap it up, those of you who deal with wage and hour litigation in California are familiar with California's Labor Code Private Attorney General Act, or PAGA, affectionately known as the Sue Your Boss Law, which allows aggrieved employees to sue on behalf of the state to collect civil penalties for violations suffered by aggrieved employees. There are a number of states throughout the country that have found this to be a remarkably great piece of legislation and have been trying for the last couple of years to enact their own versions of PAGA. And those states are New York, Washington, Maine, Vermont, Massachusetts, and Connecticut. So far, they've not gotten much traction, but they're of concern and something to watch for in terms of legislative developments. So that's it from the wage and hour class and collective action front.
Thanks, Matt, and thanks, Bethany and Trent, too, for speaking. And on behalf of all of us, thank you all for joining. I think CLE information was included when you signed up, and we are submitting that for you. But if you have any questions about that, feel free to reach out to any of us. And if you have any questions or follow up on anything that any of us said, feel free to reach out to us as well on that. Hope everybody has a good rest of the week. Thanks.